Yes.
Take two. I'm delighted to have been asked to chair this webinar this evening. You're now seeing three faces in front of you don't normally see in a row. Normally you'll see me on one side of the court and these two on the other. But I'm delighted to be here tonight, chairing this webinar on a very interesting topic. I'm sure we'll get to learn a lot. We're dealing in a number of issues arising in medical cases. In a few minutes, we're going to hear from Vikram on a series of cases involving best interest decisions with a number of interesting and controversial, perhaps, procedural issues. But first, we're going to have Fiona talking to us about the recent decision of the Supreme Court in the Abbasi case. Fiona Paterson is one of the rising stars of the medical bar. She's been in front of me on many occasions in the Court of Protection and in the High Court and in the Court of Appeal. And we look forward to hearing what she's going to say on the interesting case of Abbasi. Over to you, Fiona.
Just bring up some slides. Got to share a screen first of all, and then I can take you into the slideshow. Don't worry about scribbling frantically. I understand that you're going to be sent the slides after this evening. So all the citations, the material is going to come up in front of you and will be sent to you shortly. I might be described as a little bit invested in Abbasi because I appeared led by Gavin Miller, KC, in all three stages of the proceedings in front of the President, the Court of Appeal, and latterly in front of the Supreme Court in April 2024. We finally got a judgment a couple of months ago in April 2025. What I'm going to give you is really something of a whistle-stop tour because it's a 66-page judgment and I'm going to try and crash through it for you in the next 20 minutes, giving you the key points that will hopefully be of use if you are faced with proceedings either in the Court of Protection or the Family Division of the High Court. Just by way of a little bit of lingo, I will probably refer to injunctions rather than reporting restrictions orders or transparency orders, simply because the Supreme Court themselves said that they were a bit concerned that the term reporting restrictions order might be confusing and that what we were talking about here were contra mundum, in other words, against the world injunctions. And when I say against the world, because that can be a bit confusing too, what I mean by that is an injunction that is granted against not just named individuals or identifiable individuals, but against the world or anyone who comes across the injunction or should know of it. So with that in mind, we'll try and move slide. Do you want to try that?
Right.
No, we seem to be a bit stuck.
Okay.
Here we go. Right. Okay. Well, what was the issue that was in front of the court? It's quite simple, really. It's about how do you balance the right of privacy, in this case, privacy of doctors and nurses who've been involved in looking after children with life-limiting conditions who've been the subject of best interest proceedings in the Family Division, with the rights of the freedom of speech of their parents, particularly after the proceedings have concluded. And if they have something that they want to say, which they claim is in the public interest, both sets of parents in these appeals claim that they wanted to bring bad practices within the NHS to light. They were not interested in besmirching individuals. They wanted to tell their story with a view to improving and enhancing standards within the NHS, thereby benefiting future patients and in particular enhancing public interest. So it won't surprise you to hear that there were two very powerful perspectives to this appeal. First of all, the clinicians and those who looked after them, their employers, the trusts, but also the Royal Colleges who joined the proceedings as interveners, and also those who supported the parents. In essence, what they were saying was that giving reporting restrictions orders or transparency orders to trusts which go on indefinitely, in other words, beyond the death of the child or the patient at the centre of the proceedings and the proceedings themselves, is effectively a gag on freedom of speech. So what were the legal issues? We've looked at the emotive issue of the human side of the case. The two legal issues were, does the High Court actually have jurisdiction to make these orders in the first place? For those of you who practice in this area, that might sound extraordinary, given that it's something that is familiar to all of us. And then secondly, how do you balance the right of privacy with the freedom of speech? In other words, the Article 8 and the Article 10 rights that are at play in these cases. It won't probably surprise you that much either to hear that both the President, who heard the parents' application to lift the reporting restrictions orders at first instance, and the Court of Appeal agreed that the court did have jurisdictional power, or power, to make reporting restrictions orders in the first place, and that the practice that we've all seen in the Court of Protection and the Family Division of the High Court actually had a solid legal basis. The balancing issue between the Article 8 and 10 rights was where the President and the Court of Appeal parted company. The President came down strongly in favour of the rights of privacy of the clinicians and thought that these injunctions or reporting restrictions orders should continue indefinitely, particularly given the experiences commencing with Charlie Guard of clinicians suffering harassment both online and in person. But the Court of Appeal took a rather different view. Although it made a lot of sympathetic comments in its judgment about what those involved in breast interest proceedings were often subject to, and the impact it might have not only on clinicians, their advisors, but also those advising them, it went on to observe that really what the Trust was seeking in seeking indefinite anonymity was a carve-out for doctors and nurses that was completely different from the rest of the population that came before the court, and that this was an intensely political issue which really should be decided by Parliament, not the courts. So it won't surprise you to hear that the reason we're here is that the Trust successfully applied for permission to appeal to the Supreme Court, having been turned down by the Court of Appeal. Ultimately, the Supreme Court dismissed the appeals by both trusts, but it confirmed that the High Court has jurisdiction to grant reporting restrictions orders to protect the identities of the child or the patient at the centre of the proceedings, the treating clinicians and the hospital staff while the proceedings are afoot, but that the practice of granting, in effect, indefinite anonymity at the outset of proceedings to clinicians was actually legally flawed. However, within the judgment, which runs to, as I said earlier, 66 pages, it handed down a great deal of useful guidance. If you are a little short of time, I suggest that you read paragraph 182, which summarises the conclusions within the main judgment by Lords Reed and Briggs, and also Lord Sale's short concurring judgment, which focuses on the period or the duration of the injunction while the proceedings are on foot and are being issued. It again gives a helpful perspective about various scenarios which may not be covered off in the very comprehensive main judgment. So the court, or the Supreme Court's starting point, is really at paragraph 43. This is one of the, where it summarises the crux of the issue on these two appeals, which is that if an injunction has been granted, a reporting restrictions order at the start of the proceedings, which on its own terms doesn't cease to have effect at the end of the patient's life or after a specified period, the consequence of that is a permanent restriction of disclosure which remains in place, detached from the proceedings to which it was ancillary as a mechanism for avoiding collateral damage, and from the treatment it was designed, at least in part, to protect from the deleterious effects of publicity. So in other words, what the Supreme Court was saying there is that this is highly undesirable, that these injunctions, as they had in the Abbasi and the Hasrat case, are just left hanging there after a patient has died and the proceedings have come to an end. If injunctive relief is to continue, it must be on some other basis. And at that stage, if not earlier, it may well be reasonable to expect any application for continuation of the order to be supported by evidence concerned specifically with the circumstances of the case before the court. In other words, by the time the patient has died and the proceedings have come to an end, if the anonymity of injunctive relief is going to continue at that point, those seeking that relief have got to come forward with evidence about their circumstances, their individual circumstances, and why they still need the benefit of anonymity. So what the Supreme Court did was to say that there are really 4 periods during the life of a serious medical treatment case, and that the necessity or the continuation of the reporting restrictions order, the transparency order, or the injunction needs to be seen through the prism of these 4 periods, because the court has a different jurisdictional basis during these 4 periods, and different considerations come before it, and therefore the quality and the nature of the evidence which is necessary to secure the injunction is inherently different. So the institution of the proceedings, something we're all familiar with. The case often starts off like a rocket. There's a mad rush to get the evidence ready, and the focus of everybody, quite rightly, is the welfare of the child who's at the centre of the proceedings, or the adult who is at the centre of the proceedings. There's then the second period while the proceedings were ongoing and the child or the patient is alive. And then, as we all know, we can suddenly find ourselves with these proceedings coming to an end almost as fast as they started, either because sadly or tragically the patient doesn't survive, or the very nature of medical treatment cases is that they are short and fast and often decided within a matter of days or weeks. So after that, we have what's known as the cooling off period. Now, many of you who practice in this area will be familiar now with seeing orders, particularly in the last couple of years, specifying that the injunction will continue until 28 days after the patient or the child's death. That's your cooling off period. And then finally, the indefinite period thereafter, which is once your cooling off period is ended, the forever period. So the court's starting point, as you will see from the judgment, particularly paragraphs 43 and 47, is really an acknowledgement of the speed with which these proceedings start, and that it's unrealistic when everyone, particularly the clinicians and the parents, are under such pressures to have anything other than the best interests of the child or the patient at the forefront of their minds. But as a matter of law, there is a large degree of overlap between the child or the patient's interest in anonymity and those of the trusts and the individual clinicians. However, the factual and the legal landscape change rapidly, either with the death or the end of the proceedings. So starting with the first and the second periods, that's the institution of the proceedings or the issue of the proceedings, and while the proceedings are afoot and the patient is still alive. The Supreme Court has said that the jurisdictional basis during these 2 periods are the court's inherent jurisdiction. And that has 2 facets. First of all, the parent's pactory jurisdiction, the jurisdiction to look after, the court to look after the welfare and well-being of children and incapacitated adults who fall within its jurisdiction. And then secondly, the court's own inherent jurisdiction to protect the administration of justice, in other words, the integrity of its own proceedings. The justification at that stage is quite straightforward. It's the child or the patient's Article 8 right to privacy, and that is balanced obviously against the press or the parent's right to Article 10, freedom of expression, but at that stage, invariably, the balance will come down the side of the Article 8 rights privacy. The evidence at that stage can be quite straightforward. In other words, it can be generic. You can, if you're acting or advising for trusts or clinicians, rely on evidence of what has happened in previous proceedings. By way of example, you could talk about the experience of trusts such as Great Ormond Street or Alder Hay in cases involving Charlie Gard and Alfie Evans. It's perfectly acceptable, the Supreme Court has said at that stage, for the court only to be concerned with the background or the generic risks. But as we'll find out as we go through these slides, even at that stage, you need to start, if you're advising the trusts and all the clinicians, you need to have an eye on the evidence that you're going to need to rely on once the proceedings come to an end, or the patient dies if you want the injunctive relief to continue. Also, what has come through this judgment, particularly if you look at Lord Sale's short judgment, you need to have one eye on whether any doctors or nursing staff who may wish to pursue injunctive relief at the end of the proceedings, in other words, after this calling off period, whether they should be being joined to the proceedings at this stage, not necessarily with a view to arguing their own case, but just to make sure that there are no procedural missteps and you're caught out either as the patient dies or the proceedings come to an end. So, moving on to the cooling off period, this is what we often see at the moment as the 28-day period post-death, if that doesn't sound too cold. At that point, the jurisdictional basis for the injunction changes, or at least this is what the Supreme Court has said. The parens patri aspect, the parens patri aspect of the inherent jurisdiction falls away, and as the proceedings end, the court's inherent jurisdiction to manage its own proceedings also falls away. But a new potential form of jurisdiction or basis of jurisdictional power emerges, and this is what the Supreme Court have loosely termed the broadward jurisdiction. In other words, at that point, the trust, if it wishes, can argue that the order needs to continue to enable it to carry out its statutory functions. If I give you a very practical example, those of you who are familiar with the Alfie Evans case will remember that there were difficulties of ambulance crew bringing new patients into Alderhay during the proceedings involving Alfie Evans. Were those difficulties to have continued after Alfie had died and after the proceedings had come to an end, Alderhay could have argued that we now need injunctive relief to continue because we cannot bring new patients into our grounds via ambulances. Therefore, we need injunctive relief, or we need the RRO, transparency order, report protection case, to continue in order to protect, say, the names of our accident and emergency clinicians, and possibly even the trust itself, depending on the circumstances. As you'll see from the bottom of the slide, the justification for the jurisdiction being invoked at that stage is the trust being able to carry out its statutory functions. But there is a further basis for arguing that the court still has power to continue the injunctions, and that is if you find yourself in a set of circumstances that were the injunction to be brought to an abrupt end, there would be an obvious infringement of the Article 8 rights of the clinicians, say, or an inability of the trust to continue to perform its statutory function. You could argue that under the court's equitable jurisdiction, the injunction should continue for a short period of time to enable either the trust to pull together evidence of the need under the broadward jurisdiction, or the clinicians to argue their own case. We'll look at that at the moment, possibly that their rights to privacy or their Article 8 rights would be infringed without the benefit of the injunction continuing. So it won't surprise you against that background to hear that once you get to this cooling off period, the generic evidence is no longer sufficient. At that point, if either the trust or the clinicians want to argue that the injunction should be continued, they need more. They need to put in evidence of the circumstances which they as an individual trust or as an individual clinician are facing, and what the consequences or the risk of the consequences will be if the injunction is lifted. So what about after the cooling off period? Now, this is the period which has been termed by the Supreme Court as the indefinite thereafter, or the forever period. Although the High Court clearly has the power or the jurisdiction to grant further injunctive relief, at that point, what the Supreme Court has said is that the clinicians, because it's assumed that it will be clinicians who are seeking relief at this stage, actually have to pin their colours to the mast and decide upon their own course of action. They've already headed up the fact that they think it is most likely that a clinician in those circumstances would rely on invasion of privacy as a basis for an injunction. But by that point, they've made it quite clear that the court would need a pleaded cause of action, a body of evidence, the generic evidence no longer being enough, and it is no longer sufficient for the clinicians to be described as an undifferentiated group, namely the staff who have treated patient X or Y. Staff at that stage either need to be named as individuals or need to be a distinct group, possibly represented by a senior clinician who they've nominated. So what happens if you're faced with the slightly unusual situation of the child surviving beyond the end of the proceedings? It might be that the trust application withdrawal of treatment is dismissed, or that the child has survived or the patient has survived against the expectations of the treating team. Well, in those circumstances, the Supreme Court has said that you can still rely on the parent's patrie jurisdiction, because as the child, the patient continues to live, that jurisdiction is still there, but only if the child remains or the patient remains in the care of the NHS applicant trust. The Broadmoor jurisdiction is still there if there's a continuing threat of behaviour which will interfere with the performance of its functions. But if the clinicians at that stage still want to pursue their own rights or enforce their own right to privacy, they must apply themselves, in other words, as individuals or a group, possibly represented by a nominated clinician. So you may be wondering, those of you who are probably only too familiar with the position statements that are frequently prepared by people like Vikram and me, what has happened to Lord Stein's dicta in Reyes about the balancing of Article 8 and Article 10 in all of this? And surely that was the answer that everybody needed. It was a question of looking at the case on its facts and really having a look at what was fair. Well, what the Supreme Court has said is the concept of balancing as described in Reyes is just too vague. What you must do is start with the text of Article 10 and Article 8 and ask yourself whether, if the injunction is granted, whether that constitutes an interference of Article 10, or if it's not granted, whether there will be an interference of the clinician's or an individual's Article 8 rights. Then you need to ask yourself whether that interference is one of those interferences which is described within the text of the convention as being prescribed by law. And then finally, whether that interference constitutes a legitimate aim. If you look at Article 10.2, you will see there are a whole list of circumstances in which a legitimate aim one can say that a curb on freedom of speech can be described as a legitimate aim, particularly the protection of health or morals. And one could argue that protecting the ability of an NHS trust to perform its statutory functions would, in those circumstances, just looking at the text of Article 10.2, be a legitimate aim. And then finally, what you must ask yourself is the interference necessary in a democratic society? And it's at that stage that you start the Reyes balancing, which is obviously a highly fact-sensitive exercise. So you still look at Reyes, but if you're drafting a position statement, you've probably got 2 or 3 paragraphs ahead of your Reyes Lord Stein quote that we all churn out before you get to your final balancing bit. So what does all of this mean? Well, what the Supreme Court have concluded by saying at paragraph 178 of their judgment is that, as I've just touched on, the protection of clinicians and other staff working in public hospitals from unfounded accusations is a legitimate aim. And many of you who work for trusts will know that one of the most commonplace fears amongst clinicians is that they will be criticised in a manner that's unfair, which damages them reputationally indefinitely, because once it's up on the web, it is jolly difficult, as we all know, to make sure that material which may damage someone's reputation is brought down. It's reasonable to infer that analogous reasoning could also apply to the protection of such persons from other forms of intrusion upon their Article 8 rights. In other words, the protection of that individual's right to a private life, peaceful enjoyment of their home, not just their professional reputation and their professional life. However, such a restriction will only be compatible with Article 10 if it meets some important requirements, including that it does not impose a disproportionate restriction on debate on matters of general public interest, and it does not prevent responsible criticism, including personal criticism, in cases of legitimate concern. Now, to give that a bit of context, what the Supreme Court has said is that senior clinicians are public figures. They have Article 8 rights, but in the course of their professional lives, they are carrying out public duties. And therefore, if they are underperforming, and there is a proper and legitimate basis for saying that they are underperforming, that is a matter of public interest. And it will not be an interference of their Article 8 rights for such material making those criticisms to be published. That is quite a step forward because the case, it won't surprise you, was argued before the President and the Court of Appeal on the basis that clinicians are private individuals. They're not politicians or pop stars who place themselves knowingly in the public arena, and they are aware as they qualify that this is what they're setting themselves up for. That argument was met with some sympathy, certainly by the President and to a degree by the Court of Appeal. But the Supreme Court has said no, there has to be a degree of realism here. Senior clinicians wear name badges, very often their faces and their names appear on trust websites. And the job that they do, using the facts of these appeals, looking after sick children with life-limiting conditions, is a matter of legitimate public interest, not public curiosity, public interest, and therefore properly formed and cogent criticism does not fall foul of Article 10.2 and should be allowed. So I finished this by saying to be continued. And the reason for that, you might think, well, after 66 pages of Supreme Court judgment, how can that be the case? The reason is that this is a clarification of the law, and it isn't even on the basis of this detailed judgment entirely clear how this will be applied at first instance. And so I suspect we may find that there is scope for much more judicial ink to be poured on this subject, and Vikram and I may be back in front of you again, giving you an update in a year or so's time on how the law has evolved.
Thank you, Fiona. Like so many cases, it all leads to more work from the learned friends. We're going to have some questions at the end of both our presentations today, and please use the question and answer function on the webinar. But before we do our questions on the Abbasi decision, we're going to hear from Vikram. Vikram first appeared in front of me longer ago than I care to remember now, probably 14, 15 years ago. In the seminal case of M, the first case involving creation of the minimally conscious state, which set the template for so many cases going forward. Since then, his career has flourished even further. He's now, like Fiona, one of the leading practitioners in this field. And he's going to talk to us about a series of cases involving best interest decision and practice matters. Vikram.
Thank you very much, Jonathan. So these are just a few cases that I thought were interesting that you should know about. Let's see if this works. Right. So I should say that in common with policemen, the loss of a trust is not always a happy one. I think everyone understands that bringing these cases to court is not always easy, but there are some basic things that the courts do expect from trusts. And one of those basic things that is that cases brought to court within a reasonable period of time. So the first question is, when do you have to take a case to court? And the previous jurisprudence was, well, there was a dispute or it was about something really serious. So for instance, in the Bland case, where you're talking about withdrawal of CANH, clinically assisted nutrition and hydration, you had to bring every case to court, even though there might be full agreement among everyone as to the course of action. That changed in the NHS and Y case, the Supreme Court, and the Supreme Court said where there is agreement among everyone, and there isn't any reason to think that the protected parties or that the patient's views would be any different from the relatives, and the trust also agrees, there's no need in law to apply to court, even in a case involving withdrawal of CANH. Although the court did say that there should be no hesitation on behalf of the trust if it were thought better to take the case to court. So the bottom line there is that where there is a dispute that's crystallised as best interests, it does need to be taken to court. And the truth of it is that courts expect public authorities to take the case to court. In theory, any potential party could take the case to court, but in reality, when it's a medical treatment case, trust is the body expected to take the case to court. If a trust delays making an application to court, or doesn't make one at all, for instance, leaving a relative to make the application, there may be consequences. And one example is the MR and SR case in 2016, which is the case that was also called M&N, which was the first case in which CANH was actually withdrawn from a patient in a minimally conscious state after Lord Justice Baker's seminal judgment in Re-M that made it clear the court had jurisdiction to make such an order. It took another 5 years for the courts to actually order it on the facts. And this is the cost judgment arising out of that case. So Mr. Justice Hayden had considered an application for costs in a case where the applicant had brought proceedings herself to seek an order to remove assisted feeding to her mother, and the applicant sought the cost order at the end of it, and Mr. Justice Hayden held the respondent would be ordered to pay half of the applicant's costs. The CCG's responses entailed what was described as avoidable delay, and particularly at the procedural stages, what was described as a disturbing disregard for national guidelines. The failure to follow national guidelines was inextricably linked to the applicant's decision to make the application herself, and delays had been encountered in response, and there were costs arising out of it. So the court may make a cost order against the trust which is delayed in making an application. There's been a more recent case, there have been various other cases involving delay. This was also one for Mr. Justice Hayden. I don't know if the court saves them for him. He seems to be quite good at finding out what's going on and identifying what the problem is. So in this case, a particularly striking example of a patient who was in a PVS since 2016, but the application to withdraw CANH was only made in February 24, leading to a hearing in January 2025. There had been evidence from two eminent neurorehabilitation experts that on the facts of this case, CANH was futile, and in an earlier judgment, Mr. Justice Hayden had concurred in that assessment, holding CANH to be both futile and indeed burdensome. But he said in this further judgment, which addressed the issue of delay by the ICB, a failure to properly address patient's best interests in a timely way has compromised his dignity. And in the case itself, the official solicitor, whose counsel I think isn't sitting very far away from me, said that if there was identifiable disagreement within the family, proceedings should have been commenced no later than 2018. And in that case, the immediate family all held clear views that continuing treatment was entirely contrary to what JP would have found tolerable, mirroring the facts in certain other cases, including the Re-M case. So, court, Mr. Justice Hayden, summarised his judgment in saying that an attempt to obtain full agreement or to obtain second opinions isn't a good reason to delay issuing proceedings. So just because you think that the family are disagreeing at the moment and might come round, it's not a good reason not to issue. And similarly, the desire to obtain further opinions is not a good reason if it will lead to a material delay in the determination of best interests. So we know there are cases where such delay occurs, and the courts are not going to let them go. They will certainly examine the facts and criticise it. So I've got some tips to try and avoid or mitigate delay in litigation. I think one point I would add that I haven't put on the slide is, I think there needs to be more education of clinical staff as to what the legal issues are in cases of incapacity. Sometimes they need to be educated as to look at whether there is incapacity in a particular patient. Sometimes they go on for years and years without realising there's an issue of capacity. But they also need to be able to get a sense of when it will need to go, when they need legal advice. And obviously there's a stage of internal hospital legal advice and then external solicitors. So I think the clinical staff do need education, and that's not an easy task because there are many of them and limited resource in terms of teaching, but that's probably where I start with. Then I would also recommend that the external solicitor attends the best interest meetings, or at least the later ones, so that they can do two things during that hopefully last meeting, so that preparation for litigation can start as soon as the decision is made in the best interest meeting that it may need to go to court. And then critically, they can obtain instructions to give the official solicitor the 50% cost indemnity in the best interest meeting, as opposed to waiting a few more days after the decision's been made. But then the trust perhaps needs to meet again to make that decision, because it's obviously not without consequence. Then the next point is, it's important to engage with the official solicitor effectively. And I think that requires one to try and understand what the working practices of the official solicitor are. And there's a helpful note to do with appointment of the official solicitor in welfare proceedings. I put the link up there, you'll all be familiar with it. And the official solicitor has said she won't insist, as she would normally do in a welfare case, that she is litigation friend of last resort. Then what else? How can you get the official solicitor to most effectively engage with your case, as opposed to all the other cases which are being mentioned, but which may not eventuate into a proper case? Well, my own sense is that it's not enough simply to ring them and tell them about a really interesting potential case that you've got, because the official solicitor gets a lot of phone calls like that. And my sense is, although I haven't had it confirmed, that only a small proportion of such calls turn into actual substantive cases. And they can't treat each call as if it was an actual case. So looking at it from the OS's point of view, you've got to see that every phone call they make, obviously they make a note of what may happen, but if it's not going to eventuate, they're not going to be able to treat it in the same way as if it's a case that's about to be launched. My next tip is I would give them a 50% cost indemnity straight off. When you're ringing them about the case, you should already have instructions for the cost indemnity. Because the reason I'm giving you this list of tips is that a couple of days delay can make quite a difference. And if the official solicitor doesn't have time to send an agent to go and speak to the patient, then as a trust, you've got a problem, because there is then a gap as to what the patient's wishes and feelings are. And the official solicitor is the best person to go and work that out. And you need to give her a bit of time, because your case isn't the only one she's doing. I suspect. It may feel like this is the only case you should be doing. Your case might be the most important case on that day, certainly to you it is. But I'm just trying to give practical advice as to how to get your way up the list of cases the OS is going to look at. So give the cost indemnity at the same time as calling them. Why would you need to wait to obtain instructions on something you know you're going to have to get? If it's one of the things that you will need to get the solicitor to work on your case. The next thing, and I know this is a bit controversial, but I think it's right, is to compile a paginated bundle with not only the notes, the immediate notes. You don't have to have years worth of notes, but let's say the last month's worth of notes, or possibly 2 months, with draft orders, not only just for directions, but also substantive treatment. So if it's a paginated bundle, everyone then knows where everything is. And you can obviously add to it, but the court will like it much better than if you send them 10 different documents. You've got some nice COP forms, you've got a couple of witness statements possibly coming in at different times, maybe in order for directions, but no substantive order. If you just try and make it easy for everyone that you want to get things out of, I think it can help. So paginated bundle, not simply an application with different forms in it, because then you know each person you'll send it to, court and the OS, they've got all the documents you want, because it's a 67-page bundle, and they can then check if they've got 67 pages. The next tip is give the OS a realistic timetable for when you're going to try and get the substantive hearing done. And it might be tomorrow, but then tell them that they're not going to like it, and the court will want to know why suddenly you have to do it that quickly. But if you can wait till next week, the OS then has a chance to think, well, can I send someone? And then final point is identify how complex the case is and instruct suitably senior counsel. Some cases are much trickier than others, and it's good to identify that early. Right, another on my list of things that you want to not do if you can avoid it is when you're in litigation and you've got people on the other side, it is good to try and disclose relevant documents as soon as possible so they may fairly participate in the hearing. In the Birmingham Women's and Children's Hospital and KB case, the judge, having ruled on a case where a child had a rare and serious genetic health condition, and the NHS Trust applied for declarations to discontinue life-sustaining treatment, court found that there were significant delays in the disclosure of essential medical documents. And they weren't just minor documents, it was a sort of primary source material, such as interaction records, so records of the child's interaction with the outside world that went to the core assessment of burden and benefits. And I think a week before, there was something like 3,000 new documents, and leading counsel and junior counsel applied on behalf of the parents to vacate the listed hearing on the basis they wouldn't have time to read it. The judge didn't adjourn the whole hearing, but delayed the start date by 2 days, and the hearing was able to go ahead, and the best interest decision was issued, actually refusing the trust's application for declarations. And the judge then gave a supplementary judgment giving reasons for the refusal to vacate. And the court said, refusing the application to vacate, that in cases concerning discontinuance of life-sustaining treatment for a child, where the issues were life and death without hyperbole, there was an obligation to put before the court the material necessary properly to make an evaluation of the evidence to reach a decision on the serious issues. And it was therefore unacceptable to take a casual approach to ensuring that the records required in direction were before the court. And the public body had behaved in an unreasonable fashion. They had essentially required counsel to make repeated applications for disclosure, which was not acceptable. And there's guidance at paragraph 21. I think there are about 8 different points which trusts would be well advised to be aware of. Essentially, it involves having to anticipate having to make disclosure in advance, and there should be a senior person in the organisation in charge of it. Again, it should be indexed and paginated. And I know it sounds trivial, but having had a very glancing experience of actually sitting the other side of the course, it is really very handy having paginated bundled, preferably in advance of the hearing. Right, next topic, expert evidence. And I'm just highlighting the similarity in the rules in cases involving children and adults in the medical treatment sphere, and an interesting recent case where there was more reluctance to order to allow each side to have their own experts. So under the inherent jurisdiction, the family procedure rules, rule 25.4 subsection 2, gives the court power to put expert evidence to the court only if the court's opinion the expert evidence is necessary to assist the court to resolve the proceedings. And the COP rules, you'll not be surprised here, are very similar. Rule 15.31, the test of necessity, and similarly, I think it's 15.3 as well. I think it's fallen off the slide, but the test is necessity only if satisfied the evidence is necessary to assist the court to resolve the issues. It can't be resolved either by a Rule 1.2 representative or in a report under Section 49. So arguably, the test in the Court of Protection is more strict. There are other ways in which the court can get expert evidence. In the ATN and BTN case, a B with a 17-year-old born male, sorry about the typo, identifies as female and has been prescribed female hormones for gender congruency by an NHS GP. There's a dispute with parents over the advisability of gender-affirming hormones. The parents sought permission to instruct both their own psychiatrist and endocrinologist. Permission to refuse a psychiatrist was refused, there being no prima facie evidence of incapacity, and also permission to instruct their own endocrinologist was also refused. So the court gave the parties permission to instruct single joint endocrinologist. The court said, I'm not able to accept counsel's submission that cases concerning the medical treatment of children form a special category in which it's practiced to allow second opinions as a matter of course. There are no rules mandating it. But the interesting question is, the test for expert evidence in the inherent jurisdiction and the Court of Protection is the same or very similar necessity, and it is absolutely routine for the Court of Protection to give the OS or parents permission to instruct their own experts without going through the single joint expert procedure first. For instance, one example, but there are many, is the Tafida Rakib case, where same judge actually, as it happens, heard a case where the parents had their own UK paediatric neurologist, paediatric intensivist, plus there were doctors on behalf of the parents from the Ghaslini Hospital and various other specialities. So there does seem to be a more narrow approach, at least in this case, to the instruction of second experts. The next case is a case involving anorexia nervosa and the type of treatment that the court may, in extreme cases, authorise. Usually, the treatment for anorexia nervosa is given under the compulsory treatment powers in the Mental Health Act. So it's not routine for the Court of Protection to hear applications for feeding under restraint, for instance. The Court of Protection more typically hears cases where the trust is seeking to stop treating, but it has also heard cases in which more onerous treatments are offered. In the St. George's and LV case recently, the trust applied to treat a 20-year-old woman with anorexia nervosa with a BMI of 11.4 with a period of feeding in ITU. Her condition had unfortunately deteriorated with lockdown and it was now critical. And the interesting analysis in the case involved the inference of wishes and feelings. She had said she wanted to die on occasion, but the court inferred from holistic analysis of all the other evidence, including evidence that she had been inquiring about new treatments and also regularly visiting home to do activities like plant seeds, check on their growth, visit the animals at home, and also she was planning projects for family members to carry out in future, persuaded the judge that in truth LV did want to live and the application was granted. Final point, this will give great pleasure to the media or anyone else watching court cases. This is a quote from a judicial review case with potential relevance to court of protection and family division cases where they're conducted in public. Mr. Justice Fordham said the following: two members of the press attended the High Court hearing, each requested a skeleton argument. Experiencing a delay, they rightly raised this with the court. I made an unopposed direction for immediate provision of the skeletons. Counsel flagged up a paragraph in one skeleton whose reporting could have fallen foul of the reporting restrictions, and I've been invited by two members of the press to record the position in law. So he does that. Skeleton arguments relied on at a public hearing should ordinarily be made available to the press promptly on request at the hearing, in paper or electronically. This promotes open justice, provides contemporaneous reporting in public confidence, and often it's entirely appropriate for skeleton arguments also to be available to members of the public who wish to understand the hearing. Any person wanting a skeleton argument should identify how this will advance open justice, a threshold often easily cleared by reference to understanding the case. So it follows from all of this that advocates, and this is the punchline, should come to a public hearing prepared promptly to provide their skeleton argument, having thought ahead about any countervailing factor and bringing any contingently redacted version. Right, that's probably enough or more than enough for me. So we might look at the questions now.
Yes, well, thank you very much, Vikram. We're going to just look to see what questions we've got, if any. We have got some questions, I hope.
Have you got some questions? Okay.
Right, let me have a
Right.
right.
To Fiona, is it?
Yes. This is a question from an anonymous attendee. On the anonymity point, how were senior clinicians defined? And what's the position in relation to cases involving private sector organisations? Would clinicians in those organisations be considered to be performing a public service despite being privately contracted?
Dealing with the first question, they weren't defined, is the answer. The inference I would draw from factual circumstances is that what the court was loosely describing as senior clinicians would probably be a consultant. In other words, somebody who would probably be on many trusts, not all now, trusts website, as somebody who's responsible for a particular area or department or had shared responsibility for it. In relation to consultants or senior clinicians, because I'm assuming somebody's working in the private sector, they're probably at least at, using old-fashioned terminology, senior registrar level, most probably registrar level, unless they're the medical officer. I think they still would be regarded on the analysis that we see in Abbasi as senior clinicians, even if they're in a private sector, if they are carrying out NHS care, which has been contracted by the NHS. But in a set of circumstances where a clinician working in a private hospital wasn't providing NHS care, but was just privately contracted services to a particular patient, we consulted them on a private paying basis, either directly or through an insurer. I can't see why there would be any less public interest in knowing how that clinician performed or how the clinic or hospital, even if it were private, were delivering clinical services. So I think the same considerations would apply.
Yes. Can I just ask a question arising out of your talking? And I'm not expressing a view, I'm just putting a question, but I imagine it's a question which will be formulating in the minds of lots of clinicians, if there are clinicians watching this evening. The idea that clinician is a public figure, not an expert witness, but treating clinician as a public figure in a way which We can understand that a rock star is a public figure, a footballer, and even a judge is public. But the idea that treating clinician as a public figure is quite a striking development.
I think the language in the judgment is slightly more nuanced. I may not have put it as clear as I should have done. It is somebody carrying out a semi-public function in delivering or making, say, a decision to withdraw treatment from a terminally ill child.
Okay, so a clinician in certain circumstances.
Yes.
But these will be, as it were, ordinary clinicians.
Yes.
There won't be people who are customarily witnesses in court.
No.
And to what extent do you think that that's been accepted by the profession, as far as you can understand? The idea of them being joined as parties to proceedings, that seems like a very striking, and I would imagine many clinicians consider it an alarming development.
Well, I think they have found it an alarming development. I mean, I think what runs through the judgment are two sort of strands. First of all, tremendous sympathy to the pressures that the clinicians are under as the proceedings start. But that is countered by, should we say, a salutary note that runs through the judgment that if you want injunctive relief beyond the end of the proceedings or the patient's death, you must either apply for a clinician to be joined as a party or form a group with your colleagues, possibly issuing representative proceedings. But even though that may sound initially a staged and a measured approach, I think the onus on individuals is quite something, because it is a huge step forward for someone to put their head above a parapet who's in a clinical role, even if they're doing so as part of a group, and say that they wish to pursue an injunction to protect their privacy rights. Whereas, particularly up until now, we're talking about 10 plus years of case law, they've enjoyed the umbrella protection of the trust.
Yes. To what extent do you think there's a concern that this may impact on clinical judgments?
I think there is a very widespread concern. Certainly much of the evidence that was put before both the Court of Appeal and the Supreme Court from the interveners from the Royal Colleges and indeed the two appellant trusts focused just on that point, that with refusing to give lifelong or indefinite anonymity almost as a matter of course, as had been previous practice, you are essentially putting clinicians who've got to make very difficult decisions, often in very pressured circumstances, under even greater pressure. And it is inevitable that in some consequences they will take the route of least resistance, if only to be able to continue practicing themselves and looking after other patients.
Yes.
I've got a question actually. What sort of evidence is going to be needed to establish that an injunction is going to be justified? Because these things can develop very quickly, can't they? If you just have some sort of anonymous internet threat quickly turning into a threat in person.
Well, I think this is why I caveated the end of my session with, it remains to be seen how this is actually going to pan out at first instance and what the threshold will actually be for injunctions in such proceedings, because you've articulated the fact that clinicians will invariably find themselves between a rock and a hard place. You can have a sense that you're going to be pilloried on social media, but being able to actually prove that that will happen ahead of the posts actually starting is nigh on impossible.
We had a series of further comments in the chat, questions, I think probably by discussion you and I have just had, Fiona.
Yeah.
Can we just go down to the second one, from Sarah, from an ICA consultant in London. She says going to court will never be a unilateral decision by a single consultant. It only happens when there's a consensus and following external second opinion. That's what it is. Therefore, she says it's a group sport, not a single person sport. So why should a single person be named? Surely it should be the group. It's named by the ICU consultants from X hospital.
Well, I think what the judgment says is that you could have somebody identified as an individual to bring the proceedings on behalf of the group. I don't think what the court was anticipating was an application being made by one consultant on behalf of the entire ICU consultant group or all the ICU staff. It would be that for the sake of administrative convenience, the lead consultant may be the person who is joined to the proceedings and named as bringing the proceedings in a representative capacity on behalf of his or her colleagues.
And then another comment from the chat. And the second point there, if an anonymous group of staff have historically received threats, death threats on social media related to cases, and sadly that happens.
Yes, we know.
How do they demonstrate that they remain at risk?
Well, I think, Sophie, what's needed is to look at when the last threat appeared in terms of, I mean, it's going to vary from case to case. But I think it's a question of looking at when the last threat appeared, the intensity of the threats, the frequency of them when they were ongoing. I mean, it's impossible to advise in a vacuum because this is intensely fact sensitive. But I think the thing that's really driven the decisions of the Supreme Court and the Court of Appeal in Abbasi and Hasdrub is that the two children died in 2018 and 2019 respectively. So it's obviously very challenging in those circumstances to show that there is a substantive ongoing threat or risk of abuse for clinicians. But I mean, I'm talking in terms that are very, very general here. I think probably what would need to be done now, if you look at the way that the Supreme Court has divided up the course of the proceedings into 4 periods, is that as proceedings are issued, while the focus of the clinicians would obviously be on the best interest evidence, someone either within the internal or the external solicitor team needs to start keeping an eye on social media and a diary of any movement on social media sites, so that by the time you get to the 3rd period or the cooling off period, you've got a record that you can put in front of the court of what the social media movement has been. Now, I say that not lightly. I realise that people are terribly stretched and resources are even more stretched. So how one is supposed to man that is a matter that remains to be seen. But that is the import of the judgment.
Seems to me that there's a need here, following events, for lawyers to put their heads together to devise a pack or a program of advice to be given to clinicians as to how to deal with these cases. Obviously, some hospitals, like Ormond Street and other specialist hospitals, will be sadly familiar with this sort of problem regularly. This is a problem which can arise in any hospital across the country at some point. And I suspect that the trusts just don't have the resources in terms of specialisms or to devise a plan of action on that basis, case by case basis. So I think there's scope for some general guidance to be given. Respectfully suggest that. That shouldn't come from the judge. It should come from lawyers. All right. Yes, another question at the top there. If a family wants an RRO, can one be granted for a longer period than the duration of the case, including off period? The answer is potentially yes, on the facts.
Yes.
The message you're giving is the longer the period, the longer the time goes by, the clearer the evidence have to be of harm, which would lead the balancing exercise to the absolute way to protect the regularity and anonymity of the conditions.
Yes, very much so. But Sophie's example was about families wanting a continue or a lengthy RRO. I mean, I would have thought that if it's going beyond the 3rd period or the cooling off period, what the family need to be advised to do is to start looking as early as they can about where the risk lies, what they are concerned about, how they think it might eventuate, why they consider it is necessary, all sort of general Article 8 type issues that anyone seeking injunction would have at the forefront of their mind. But I mean, the problem is it's almost impossible to advise in a vacuum or to think about these cases in a vacuum, because even though I've said we've moved on from Reyes, they still remain acutely fact sensitive. And that's why, although the Supreme Court's judgment is so detailed, it can be no more than really guidance at a fairly high level. It can't possibly, sitting that high up the appellate structure, get down to the nuts and bolts of how this is going to work at a first instance level. That is going to be left to the Family Divisional Court Protection Bench. So there's still some distance to go before I think we even get to the pack, probably in detailed terms.
Yeah. Yes, and for all the questions to perhaps I've got a question to you. Do you see, and it maybe applies to both of you, to what extent are these extra pressures that we're putting on experts having an impact, do you think? A, on the work of the courts, and B, on the work of clinicians?
Well, I think that the experts that we are fortunate enough to have who give evidence work very, very hard to try and get on top of the case. They're not familiar with the cases. And they generally do their absolute best to advise the court. They're going to be identified in the judgment, which is potentially a stressful thing for them. I think they tend to simplify cases rather than make them more complicated, although one might think if you're introducing more evidence, it doesn't help. But I think it does put a lot of pressure on them, and it puts pressure on the court to look at more evidence. So just on the expert point, possibly even against myself, the court needs to be careful about what expert evidence to allow, having identified what the issues really are. But I think it can be helpful with expert evidence. But maybe, as in clinical negligence, I haven't seen this direction commonly in court of protection cases. They could actually meet with the clinicians, the independent expert, make a list of what they agree and what they don't agree on and reasons for any disagreement. If they do that in clinical negligence, then it saves a lot of time.
Well, it seems to me, I know that the hospitals trusts have these days have quite sophisticated dispute resolution processes. But it seems to me that the cases that you've identified, particularly in the Abbasi case, illustrate the crucial importance of dispute resolution and avoiding going to court and over these issues. Well, thank you very much for joining us. I hope you found it interesting. We've overrun a bit. I hope that's not been too inconvenient for you. But on your behalf, may I thank Fiona, Paterson and Vikram Sachdeva for their extremely interesting presentations. Thank you for your questions, and I wish you good evening.
Bye.